Hello, and thanks for joining us. Today's presentation, Drones and the Fourth Amendment, is brought to you by the Federal Law Enforcement Training Centers. FLETC trains the majority of federal law enforcement officers and agents in the United States. In addition to providing training for over 90 federal partner organizations, FLETC provides training to state, local, tribal, and international police in advanced programs. FLETC is proud to be the largest law enforcement training organization in the country, and because our attendees join us from multiple jurisdictions, we remind you, no agency policy or procedure should be developed, changed, altered, or modified based on this presentation, and no recipient of content from this presentation should act or refrain from acting on the basis of its content without seeking appropriate legal advice or other professional counseling. Also, the opinions that are expressed here are personal and not necessarily those of the FLETC, DHS, or the United States government. Presenting today are Mary Mara and Henry McGowan. Mary Mara is a graduate of Michigan State University, B.A., J.D. magna cum laude, and Western Michigan University Cooley Law School, LLM with honors, Homeland and National Security Law. She is assigned to the Artesia Legal Division as an attorney advisor instructor and is a frequent lecturer on comparative Homeland Security law at the International Law Enforcement Academy. Prior to joining FLETC, she served 11 years as assistant prosecuting attorney and 16 years as chief of civil litigation for Oakland County, Michigan. Henry McGowan is a graduate of the University of Texas, B.A. Economics, St. Mary's University, School of Law, J.D. Order of Barristers, and the University of Notre Dame, Executive Certificate in Management and Leadership. He is assigned to the Artesia Legal Division as an attorney advisor instructor and editor of the Legal Division Workbook. He is a guest lecturer on comparative and transnational law at the International Law Enforcement Academy, and prior to joining FLETC, he spent a decade abroad supporting international legal development and judicial reform programs for the United States State Department. And now, Mary Mara and Henry McGowan for Drones and the Fourth Amendment.
Thank you all for joining us today.
Hey, thanks. Thanks for joining us. Glad to be with you.
Today we're going to be talking about drones, because we all find ourselves in the midst of the next revolution in technology, really on many fronts, including unmanned aerial vehicles, UAVs, commonly known as drones. And while it's true that drones are not new to us here in 2020, they are relatively new in terms of application, especially considering current and projected capabilities which merge miniaturization technology, in-flight capability, maneuverability, high-resolution cameras, longer life batteries for longer flight times, infrared technology, facial recognition, and even AI. Ladies and gentlemen, the game of drones is on. Drones, or UAVs, have become quite ubiquitous today. We see them anywhere from the kid down the street that just got one for his birthday all the way to large multinational corporations experimenting with using drones to deliver the products that we all want. They are a great tool for law enforcement, and law enforcement agencies across the country and really across the world have used drones for a number of years to great effect. Unfortunately, it's a double-edged sword because criminals have also used this technology for their own nefarious purposes. And for just you and I, they're quite frankly a whole lot of fun to fly. I've really enjoyed flying drones myself when I've had the opportunity. But for law enforcement, they need to know both how to use them, technologically speaking, skill-wise, and how they can use them. In other words, legally. What does the law say? So we're going to focus more on the legal side than the technical side today, being the lawyers that we are, Mary. Mm-hmm. But we do want to look at that because that's such an important issue today. And this is a powerful tool in the arsenal of law enforcement, but only so much as so that as long as we are doing it within the confines of the law. And as we've talked with law enforcement officers really from all over, a lot of common questions come up. And the overall question, of course, what is the law on the governmental use of unmanned aerial surveillance? Because it's not just flying around the parking lot above the police station. but it's used for different types of surveillance, different types of law enforcement purpose. So questions, for example, come up. Can my agency use an unmanned aerial vehicle to search for an escaped prisoner or suspect? And where can I use that? Does it really matter if it's over some woods or the public park or in a neighborhood or in an apartment complex? What about whether my agency can use a UAV to search for evidence inside someone's dwelling or inside somebody's car, or maybe even just surveilling a person as they're walking down the street, which might contain evidence? These are common questions that do come up as we are utilizing this new technology. Now, if the question is a question of law here in the United States, of course, we always have to start with the Constitution. What does the Constitution say, if anything, as to this area? Because, after all, it was written in 1787, and we certainly didn't have drones then. I'm sure, I don't know, but maybe Benjamin Franklin was thinking of some sort of winged creature of some sort when he was flying his kite in the storm, looking to electrify his king. But I don't know that the issue of drones was envisioned even in the wildest dreams of our founders. So really, does that have anything to do with us today with this brand new technology? Well, the answer is yes, because we're going to look at a particular part of the Constitution, which is known as the Bill of Rights. One of the first 10 amendments. The Constitution is allowed to be amended, and one of the amendments in particular does speak to this issue with regard to the government use of drones for things such as searches. You probably guessed it. It's our good old friend, the Fourth Amendment. Yes, as we look at the Fourth Amendment, in fact, during our time here at FLETC, we probably spend more time with the Fourth Amendment than any other one of the amendments or any part of the Constitution as a whole, because it has so much to do with the role of law enforcement in our country. The language of the Fourth Amendment, of course, is the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. That's it. Relatively short paragraph. Our federal courts, in particular the Supreme Court, has of course had to deal with questions of law enforcement and the Fourth Amendment really since the nation was founded. A couple of quotes that I pulled out that help us on our journey today as we try to uncover some pieces of this puzzle. The first one is this. The warrantless entry and search of a home is the, quote, chief evil against which the Fourth Amendment is directed. So it gives us a little clue as to the whole purpose, and really a bedrock part of it is to protect people's home against warrantless entry and search, which there's a whole history of that, of course, which we don't have time to go into today. I'm sure you're very familiar with it. Another quote that I've run across: at the very core of the Fourth Amendment stands the right of a man to retreat into his own home and there be free from unreasonable government intrusion. Aha. Unreasonable government intrusion in somebody's home. So let's keep those initial thoughts in mind as we're beginning to put the pieces of this puzzle together and find out exactly what the legal standards are for the governmental use of drones.
That's right, Henry. And as you've just mentioned, the United States Constitution is really where our starting point has to be. And more specifically, the Fourth Amendment that prohibits the government from unreasonable searches into somebody's home, their castle. And we also have federal case law that interprets the United States Constitution, and more specifically the Fourth Amendment. In this body of case law, hundreds, thousands of cases that have been developed over the years, where courts have looked at different situations and had for the sole purpose of determining whether the government's actions violated the protections that somebody is afforded under the Fourth Amendment. So we've got a big body of case law that we can draw on when we try to figure out where the boundaries are for law enforcement. We also have some guidance that comes in the form of some advisory opinions that have been issued by the Department of Homeland Security and the Department of Justice, Of course, the Department of Homeland Security has rules and guidance regarding when drones can be operated, and more specifically, they would prohibit the operation of drones in a way that's going to interfere with national security operations or perhaps some national disaster operations. And so those federal agencies definitely have something to say about the operation of drones. But when it comes to this privacy, these privacy concerns, there are some legal standards or principles, if you will, that throughout this big body of case law that has developed, that have very clearly given us some direction as to where the government can go and where the government can look under the Fourth Amendment, and more importantly, where they cannot go and where they cannot look. And so some of these concepts we're going to drill down into. We're going to talk about these in some cases that we're going to discuss here shortly. But just to kind of introduce these bedrock concepts are these things that we call open fields, curtilage, and this concept of a reasonable expectation of privacy. We call that a REP, that for short. Now, an open field, generally speaking, this doctrine basically just provides that if something is out in the open and exposed for everybody to see, it generally has a much lower expectation of privacy. But if it's on a curtilage, which is the area that is surrounding a home, now we know we've already established that a man's home is his castle, but the courts, in interpreting the privacies afforded to that home, have decided that not only is the area within the four walls of that home entitled to heightened privacy protections, but so too is the area that immediately surrounds the home. It's like a buffer zone that goes out beyond the walls of the home, and in that area that is so closely associated with the daily activities of intimate living, the courts consider the curtilage to really be an expansion of the home. And therefore, that area that immediately surrounds a home has heightened privacy protections, heightened reasonable expectation of privacy, if you will. So to date, even though law enforcement officers and agencies across this country have been employing this new technology for at least a decade, probably I'm sure more, surprisingly, no case has made its way specifically to the Supreme Court that presents the very specific question of when the use of this drone technology constitutes a search for purposes of the Fourth Amendment. Now, we may not have a Supreme Court directly on point that deals with this very critical issue, but we do have some other cases that the court decided that kind of lend themselves to this analysis. The first one is Katz versus the United States. This is a case, as you can see, is from way back in 1967, and it established this concept of people have a reasonable expectation of privacy. And if the government's going to intrude into an area where that REP exists, we're going to call that a search for purposes of the Fourth Amendment, and therefore the government needs a warrant or an exception to the warrant requirement in order to go into that area. And two cases that deal with aerial surveillance by law enforcement are the cases of California versus Serralo and Florida versus Raleigh. Now, we're going to talk about those cases because they're really interesting. And in those cases, the court had to look at the issue of aerial surveillance, not through the use of drone technology, but through more traditional aircraft, fixed-wing airplane or a helicopter. And the courts have had to decide if the government flies over this area, the person's home, which we know is the castle, and they take a look at the area immediately surrounding that home, the curtilage. Is that a search for purposes of the Fourth Amendment? We're going to talk about those cases because the court's rulings in those cases really give us a lot of insight into the way the court might look at an aerial surveillance that's accomplished by a drone. A couple of other cases that really are worth mentioning at this point also deal with the use of technology by the government in order to gather information. In the case of Kylo versus the United States, it wasn't a drone that was being employed, but it was infrared technology, thermal imaging, if you will. In that case, the police suspected that Danny Kylo was growing marijuana in his apartment, and they decided to investigate. Now, they went to his apartment, but they never stepped foot on his property. Instead, they stayed in their car out on a public street, but using this infrared technology, they were able to tell that there was an excessive amount of heat that was emanating from Danny Kylo's apartment. And using that excessive heat, which they felt was consistent with a marijuana grow operation, they took that information and they went and got a warrant. And they searched Kylo's home. And Kylo argued that was a search for purposes of the Fourth Amendment. And the government countered that how could it be a search? We never even intruded onto your property, let alone your home. But the court concluded that the use of this technology was a search, and therefore it required a warrant. Again, even though nobody ever intruded upon his property or within the walls of his apartment. Another case that looks like technology is United States versus Jones. As you can see, this was a 2012 case. In that case, very briefly, the police put a GPS tracking device on a Jeep, and they tracked its whereabouts for a long time. We're going to talk about that case, too, and what the court found to be compelling facts that led to helped it analyze this question of whether a search occurs. So let's just jump ahead, Henry, and let's talk about the Katz case.
Thank you, Mary. This is an oldie goldie from the groovy 1960s, coming at you live here in 2020. Dealing with this issue that we all know now as reasonable expectation of privacy. Very, very briefly, the facts were that there was a man by the name of Katz, and he was involved, or police suspected so, of interstate gambling. And so they listened in on a conversation that he was conducting, actually a series of them, from a public phone booth on a street, not in his house, not in his office, because they knew that would involve wiretapping. But the thought was, hey, it's not his phone booth, it's not his sidewalk. We can plant a microphone on the top and listen in on his end of the conversation. And in fact, that's what they did. They collected information. They were able to get a search warrant. And then, in fact, it was led to a conviction for the gambling charge. Well, Mr. Katz was arguably a principal gambler and appealed this case all the way to the United States Supreme Court. They looked at a number of issues, and so even though relatively low-level, fairly simple, straightforward case, but it was one of those cases that really brought up a very interesting legal question that we still rely on today, was the court's analysis. And in fact, Justice Harlan, who wrote a concurring opinion, came up with this phrase that we use so often, REP, a reasonable expectation of privacy. Well, the test for determining whether a person has a reasonable expectation of privacy is two-pronged. One is that the person must have an actual expectation of privacy, also known as the subjective expectation. In other words, they want their privacy to be private. Their conversation, their stuff, the inside of their home, their pockets. People put things in the trunk of their car because they don't want somebody else seeing it. That's kind of the idea. But that's only one side of the coin. The other side of the coin is that expectation one that society is prepared to agree with, to accept? In other words, the objective criteria. Because I could walk down the street with my cell phone, talking in full voice like I'm doing right now, and in my mind thinking, well, hey, this is my conversation. Nobody else should be listening in. But would society agree with me? No, absolutely not. If you're walking down the phone, talking on the street, everybody can hear you, and that's not any kind of invasion of privacy. So just as a quick example of that, and that is going to be a key piece of our puzzle as well. Let's look into another case very quickly that dealt with what was arguably the traditional definition of the examination of the Fourth Amendment, and that had to do with physical trespass. Because prior to the Katz case, that was the general understanding that some sort of physical trespass had to take place, which is why the officers in the Katz case thought that they were following the law, because there was no physical trespass on Katz property because he didn't own the phone booth. The Olmsted case refers to that and provides a very good analysis of the previous thought process. But the court, of course, expanded its our understanding of someone's privacy, which still resonates with us today in 2020. In Jones, back in 2012, so just a number of years ago, the court dealt with, as Mary mentioned, a trespass involving a Jeep. In fact, there was a GPS tracker that was placed underneath the Jeep as he was making his rounds, allegedly going from customer to customer for his drug business. Mr. Jones. The GPS tracker would normally require a warrant, and it did in that case, and they did get a warrant. Only the problem was that they were a little late in finding the Jeep and installing it. But they went ahead and installed it anyway, gathered lots of information, which led to the conviction of Mr. Jones. Long story short, the court said, for this case where there was a physical trespass, a physical invasion of his private property, which was the Jeep in this case, then that certainly required a valid warrant. So it did trigger the Fourth Amendment. The court went on to speculate, well, what if there was a non-physical invasion involved in tracking him? Certainly they could, officers could do so at just a good old-fashioned gumshoe method of law enforcement. Follow somebody on the street or get in an unmarked police vehicle and follow them as they're driving down the street. That's certainly not a Fourth Amendment invasion, and the court examined that. But they did speculate on, well, what if in the future we come up with a new sort of electronic device that does provide this type of level of tracking without the physical invasion, without the touching, which the magnetic GPS tracker would require, of course. But it didn't answer that question because that wasn't the question before, but it was already kind of seeing into the future, and it was reiterated in the Riley case dealing with cell phones, and I believe it's going to be very germane to the court's analysis when it finally gets there of drones as well. So we know that in this case, that if there's a physical trespass, there is a Fourth Amendment issue. If there's not, maybe not, but we don't know that for sure.
So now, with those cases in mind, that give us a little bit of an understanding of the way the court looks at this issue of reasonable expectation of privacy. The court actually took a look at a case that involved law enforcement doing aerial surveillance of an individual. And it's the California versus Serralo case. As you can see, it's a Supreme Court case from 1986. Now, in this case, I think it was a fascinating case. Mr. Serralo, the police suspected that Serralo was growing marijuana on his property. They had received a tip to that effect. And so what they decided to do was to rent a private airplane and fly over his property at a height or altitude, if you will, of 1,000 feet to see if they could see what was going on down below. Now, as the police flew over Mr. Serralo's home, they noticed that the curtilage of his home, and remember we talked about that, that's the area that surrounds the home, that's closely associated with the activities that you do in a home and therefore has extended protections. They flew over and they looked into this curtilage area, and they noticed that Mr. Serralo had actually taken steps to block off the view of what was going on his property. He had installed a 6-foot and a 10-foot privacy fence, 2 privacy fences around the curtilage of his home. Now, the police flying over his home in this private airplane from a vantage point of about 1,000 feet could look down upon his property, and with their naked eye, they could see that he sure did have a marijuana growing operation taking place, and they took pictures of what they observed, and they took that information and got a warrant to come and search his premises. They did that. They went back, they executed their search warrant, seized his marijuana plants, and they charged him with manufacturing of marijuana. Now, Serralo argued, look, that had to be a search. I had a subjective expectation of privacy. I clearly put privacy fence up. I was trying to keep things private. And so the court had to look at this issue and say, perhaps he had a subjective expectation of privacy. Maybe he did think that what he did on his curtilage behind his privacy fence was private and therefore beyond the prying eyes of law enforcement. But we've also, remember, for somebody to have a reasonable expectation of privacy, they must also have an objective expectation of privacy. And this is where Mr. Serralo lost his argument before the Supreme Court. The Supreme Court concluded you may have had a subjective expectation of privacy, but you did not have an expectation of privacy that society was prepared to honor. In other words, the court said, you should have expected that people flying over above your house at any given point in time would have the ability to look down upon your property and see what you were doing. Therefore, it's been exposed, and society is not going to give you that expectation of privacy. And so the court, in making this ruling, said the home and its curtilage are not necessarily protected from inspection that involves no physical intrusion. The court said what one knowingly exposes to the public, even in his own home or office, is not a subject of Fourth Amendment protection. Remember when Henry gave us the example about the person walking down the street talking on his cell phone? He may have a subjective or private expectation that his phone call is private, but it's not a privacy right that everybody else is going to respect because he's exposed his conversation to public view. It's the same analysis here. They said Mr. Serralo exposed what he was doing to anybody who cared to fly over his property, and therefore that was not a search for purposes of the Fourth Amendment. This was a 5-4 decision. It was a very hotly contested case in the Supreme Court when it was decided. The dissenting justices argued that Mr. Serralo certainly should have an expectation of privacy in the curtilage that surrounded his home. And they said, for one thing, maybe they flew over his property in a private airplane at a height of about 1,000 feet, but you've got to expect that technology is going to progress. And at some point, they're going to have technology that's going to allow them to get a much closer look at what's going on below than they do with this traditional aircraft available to them back in the year when this case was decided. So they were actually projecting into the future and anticipating that as technology progresses, so too is the level of intrusion that's going to be possible by government officials. And they said, besides that, who builds a roof over their curtilage of their home? People don't put privacy structures to shield what's going on their property from somebody who might happen to fly above. So they've totally disagreed with the idea that there was no objective expectation of privacy. And so Mr. Serralo lost that argument, but it was a very close and hotly contested 5-4 decision in the Supreme Court.
That's right, Mary. And so that led us to, a mere 3 years later, another case called Florida versus Riley. In that case, Florida Sheriff's Office deputy received an anonymous tip that marijuana was being grown on Riley's property. Kind of sounds familiar a little bit with the Serralo case. So when an investigating officer discovered that he could not observe the contents of the greenhouse behind Mr. Riley's house from the ground level. It was enclosed on two sides, and the greenhouse was, and obscured from view by some trees, by some shrubs, and part of Riley's actual home. So bottom line is, from street level, he could not see what was going on there. And he really wanted to be able to confirm that tip that he got. So therefore, he was able to secure the use of a helicopter and circled twice over the property in the helicopter at a height of 400 feet and made, quote-unquote, naked eye observations through the openings of the greenhouse roof. There were some panels that were missing on the roof and its open sides. And in looking through these missing panels, he observed what he concluded, the officer did, were marijuana plants. Using that information, then, the deputy was able to obtain a search warrant. And the search warrant, when they executed it, certainly revealed that the marijuana was growing in the greenhouse. So the officer's observations and the tip, everything that it led up to that point was, in fact, correct. So Riley was charged with possession of marijuana under Florida law. It was a Florida state case that made it to the Supreme Court. The trial court granted the motion to suppress the evidence here. so granted him in Riley's favor. Florida Court of Appeals reversed that, but certified the case to the Florida Supreme Court on the question of whether the helicopter surveillance from 400 feet constituted a search, a Fourth Amendment search, for which a warrant was required. Now, remember, he got a warrant a little bit later, but that was after he viewed the top of the greenhouse from the helicopter. All right. So the Florida Supreme Court reversed the Court of Appeals decision and reinstated the trial court's suppression order. So it had gone back and forth. Well, it made its way, long story short, to the Supreme Court, U.S. Supreme Court. And the Supreme Court said that although Riley had a subjective expectation in his greenhouse, there was evidence to support that subjective expectation, which is one side of our coin. It also held that Riley's expectation of privacy was not reasonable, not one that society was willing to accept, and therefore upholding their decision in the Serralo case, and relied heavily on that 5-4 decision. The court explained that the inspection was made from a helicopter, in this case, of course, and that really was irrelevant since, as in the case of fixed-wing airplanes, private and commercial flight by helicopter is routine now. It wasn't a surprise. This wasn't in the 1930s. This was in the 80s. And helicopters, fixed-wing planes flying over people's homes were not uncommon. It wasn't so rare, the court said, that it would have just caused complete surprise. And although an aerial inspection of a house's curtilage may not always pass muster under the Fourth Amendment, simply because the aircraft is within the navigable airspace as set forth by the FAA, nonetheless, in this case, it was not an objective, reasonable expectation of privacy. That's what the court said. And therefore, that there's no evidence that the helicopter interfered with Riley's normal use of his greenhouse or other parts of his curtilage, nor that intimate details connected with the use of the home or curtilage were observed, because it wasn't looking in the window, it was looking at the greenhouse out back of the house, or that there was undue noise, wind, dust, or threat of injury. Imagine a helicopter coming down to land practically in your backyard. Of course, it would create a whole whirlwind there. So the bottom line was, in this case, observation by law enforcement from a helicopter flying at 500 feet is not a Fourth Amendment search. Now, just as with the Serralo case, there were some questions embedded in some dissenting thoughts. Justice White, who authored the plurality opinion, said, "This is not to say that the inspection of the curtilage of a house from an aircraft will always pass muster under the Fourth Amendment, simply because the plane is within navigable airspace specified by law." So, creating a little caveat there that we're ruling this way in this case, but is very limited to these particular facts. Justice O'Connor also concurred, but gave us some cautionary language here. She said that the court's approach rests the scope of the Fourth Amendment protection too heavily on compliance with FAA regulations. Mary, what's the purpose of the FAA regulations?
Safety, mostly.
Exactly. In-flight safety. And so is their business in the first place to provide privacy protections?
To the chagrin of many, no.
Exactly, and that's exactly what Justice Sandra Day O'Connor was pointing out here, that the court's approach rests too heavily on compliance with FAA regulations. That viewpoint is still reverberating today. And she went on to say, which are intended to promote air safety and not to protect the right to be secured against unreasonable searches and seizures. She also wrote, to require individuals to completely cover and enclose their curtilage is to demand more than precautions customarily taken by those seeking privacy. And so there were 3 dissenting judges calling this search a Fourth Amendment search.
There were, and in fact, I love this one quote from Justice Brennan when he wrote the dissent. And this was actually what Justice Brennan said. He said, imagine a helicopter capable of hovering just above an enclosed courtyard or patio without generating any noise, wind, or dust at all, and, for good measure, without posing any threat of injury. Suppose the police employed this quote-unquote miraculous tool to discover not only what crops people were growing in their greenhouses, but also what books they were reading and who their dinner guests were. And so actually Justice Brennan was really talking about drones.
Exactly.
Even though they didn't exist yet, he was saying the technology is going to advance to a point where the amount of information the government can acquire through the use of technology, it's going to cause very serious Fourth Amendment concerns. And so Justice Brennan really gave us a clue as to how the court might take a look at this technology if and when this question ever comes directly before it.
That was a very prescient observation that Justice Brennan made. Be interesting if Justice Brennan was still on the court today,
Yes.
or tomorrow, or next year, whenever a drone case truly does come up. So, just a very quick summary to leave us with until we go to our next section, which deals with federal regulations. Our CATS test still applicable today. A person must have both the subjective expectation of privacy and the objective expectation of privacy for it to be reasonable. Because remember, that was the language of the Fourth Amendment, to prohibit unreasonable searches and seizures. So is the use of a drone to search for evidence in a particular place reasonable or unreasonable? Well, part of that's going to hinge on this whole concept of REP. Notwithstanding the CATS REP test, so long as the government is flying at a fixed-wing aircraft or helicopter within FAA regulations in public, it seems, though, as though if they're in navigable airspace, observations with the naked eye during flight will not constitute a Fourth Amendment search, so seems that's okay. But what about drones? What about this miraculous little helicopter that didn't cause any wind or noise or anything else that Justice Brennan was talking about? Where does that fit in between this? That's a really good question. Do you think we have any good guidance from Congress, from our legislative branch, Mary?
Nope, we don't. The Congress has not written legislation that deals specifically with the issues of privacy. And that's actually, a lot of privacy advocates are very concerned about that. They wish that the Congress would step forward and pass some legislation at the national level that would go to this very serious question about privacy rights. Now, there are some federal regulations. The FAA is charged with overseeing, obviously, the navigable airspace. And most of the federal regulations that govern the operation of drones can be found in what's routinely referred to as Part 107 of the federal regs. And these regulations really are limited to questions or issues regarding safety. They govern how these aircraft, small unmanned aircraft systems can be operated, and they limit things like they require an operator to hold a remote pilot license. The drone has to remain within the visual line of sight of the operator or a visual observer. No operations can take place over people who aren't participating in the operation of the drone. No nighttime operations. No flying higher than 400 feet. And so if you look at Part 107, all of these regulations really focus in solely on the question of safety. There are some interesting federal regulations that are in the pipeline currently, but again, these proposed regulations really don't go to the issue of privacy at all. In December of 2019, the FAA released a proposed rule calling for the remote identification of drones. The remote ID is really the ability of a drone to provide identifying information that can be received by other parties while that drone is being operated. Implementation of remote identification requirements would help the FAA, law enforcement, and federal security agencies in identifying when a drone that appears to be flying in an unsafe manner or where the drone is not allowed to fly. And so it's basically like putting a license plate on a drone. The FAA has taken the position that remote ID is a necessary building block if the FAA is going to accomplish its end goal of integrating drones into the national airspace. In other words, perhaps subjecting them to air traffic control system. And if they can integrate them, this would in turn allow the expansion of operations beyond what is normally allowed under Part 107 and open the door to greater commercial use. But these are just proposed regulations. They have not been passed yet. Also, another idea of regulations that have been proposed but not finalized yet has to do with doing away with the rule that typically requires the operator to keep the drone within their visual line of sight. Also, they're talking about allowing nighttime operations. As long as the operator is trained to do nighttime operations and the drone is equipped with some anti-collision and illuminated appropriately so it can be seen from a distance of 3 miles away. So there are some regulations. The FAA is stepping into this area and issuing regulations, but again, they're really limited to safety and perhaps expanding the application of the technology into more commercial areas. But privacy advocates have even brought suit against the FAA, trying to force the FAA to issue privacy regulations, and they have not been successful in doing so. So state governments have stepped into this breach. A lot of states have started to pass legislation that puts severe limits and even in some cases prohibitions on local government law enforcement officers when it comes to the use of this technology. The trend of the states is to make law enforcement use more restrictive than what the Supreme Court has ruled. Well, they haven't ruled yet, but even the Fourth Amendment protections that are clear from some of the other cases we've discussed. States have stepped up and they have decided to put some real restrictions on law enforcement when it comes to the use of this technology. They've even made it a crime to operate drones in a particular manner. They've given civil remedies for individuals who feel that their rights have been violated by somebody else's use of a drone. And they've also, in some instances, even gone so far as to require law enforcement officers to apply for a warrant before they use a drone to conduct surveillance. And there's a great resource. It's called the National Conference of State Legislatures. They have a website, and if you go there, it'll give you updated information as to what states have taken action and what this legislation looks like at the state level. So since 2013, almost every state has now enacted laws regarding drones in one fashion or another. You can see 7 states have established certain programs for creating this legislation. They've appropriated funds in order to try to, at least at the state level, step into regulating the use of this technology in ways the FAA has not yet done so. 6 states have prohibited the use of this technology over private property or over public property, including correctional facilities, utilities, defense, telecommunications, and railroads. 3 states have implemented their own privacy protections as it relates to drone usage. 3 other states have specified instances in which evidence obtained from this technology, when it can be used in court, when it can't be used in court, for what purpose it can be used by law enforcement. And 1 state, New Jersey, has even gone so far as to prohibit this type of technology to being used to deliver medical marijuana. So states are definitely stepping into the breach and passing their own legislation and not waiting for the FAA or Congress to start taking action.
Thank you for that roundup, Mary. And so we have covered quite a bit of territory today, trying to discover what we know, what we don't know, and to anticipate where we're going. It certainly seems like the states are taking the lead in this area. And as we will get more cases coming out of the states, they will be filtering into the federal courts, we suspect, because they will probably be dealing with what we discussed with at the very beginning, the Fourth Amendment, whether that search was reasonable or unreasonable. Well, certainly this technology is here to stay. It's not going anywhere. In fact, it's continuing to expand and develop very, very rapidly right before our very eyes. The law, as usual, does not keep pace with technology. It's a slower, more cumbersome, more deliberative process, which is not to fault the legal process. It's just the nature of what it is. Technology is just leaping ahead by great measure. So we wanted to review what we have covered today to use it as a guide, especially for our law enforcement friends out there, prosecutors and judges as well, to help frame this discussion, to help us to figure this brand new technology out. We've never really had to deal with this before in the history of our nation, not quite this way, and it'll be different next year than it is right now. So let's consider where there's a reasonable expectation of privacy. When might a drone invade the curtilage? What are the Fourth Amendment parameters for law enforcement use of drones? Well, we're certainly going to be keeping an eye on Congress, different federal agencies, not just the FAA, as well as the states for additional legislation, and we'll look forward to coming back to you again at some point in the future, probably not too far distant future as fast as this story is evolving, and we'll get back to you with what we do know on that as we get further developments. In the meantime, I would suggest that you keep abreast of your agency's rules, standard operating procedures, just to be on the safe side for your operation in the law enforcement capacity. Well, that's all the time that we have today for Drones in the Fourth Amendment. So my name is Henry McGowan.
And my name's Mary Mara. Thanks for joining us today.
We appreciate your time and look forward to talking with you again very soon.